Can my employer fire me without any reason? Have you ever worried that your boss could just walk up tomorrow and say you're fired without any explanation? For millions of American workers, that fear is real. The truth is, the United States follows something called the at-will employment doctrine, which means your employer can usually terminate your job at any time for almost any reason, or even no reason at all. But here's the good news. There are important exceptions that protect you. In today's video, we're going to break down exactly when your boss can fire you without a reason, and when the law says, hold on, that's illegal. Stick around, because knowing these rules can save your job, your paycheck, and your peace of mind. And don't forget, hit subscribe so you never miss clear explanations about your workplace rights. Let's get started. Part 1. Understanding at-will employment. The general rule. In the United States, the default rule for employment is something called at-will employment. This rule exists in 49 out of 50 states, with Montana being the one major exception. Under at-will employment, an employer has the legal right to terminate an employee at any time, with or without cause, and with or without notice. That means your boss does not have to provide a reason when ending your employment, as long as the reason is not illegal. The origins of at-will employment go back to the late 19th century, when American courts began adopting the idea that the employment relationship is essentially a private contract that either party can end at any time. Courts reinforced this doctrine throughout the 20th century, and today it remains the dominant rule in most workplaces. Here's an example. Let's say you work in retail, and business slows down after the holiday season. Your employer might decide to reduce staff and simply tells you, we're letting you go. That termination, without more, is usually legal under at-will. Your boss doesn't have to show you poor performance reviews or a record of misconduct. The at-will doctrine gives them that freedom. But, and this is where many workers get confused, at-will does not mean unlimited power. There are important exceptions created by federal law, state statutes, and court decisions. For instance, your employer cannot fire you for discriminatory reasons, cannot fire you for exercising legal rights, such as filing for workers' compensation, and cannot fire you for refusing to break the law. It's also important to note that at-will cuts both ways. Just as your employer can let you go, you also have the right to leave your job at any time without notice or explanation. This flexibility is one reason employers defend the system. However, for employees, it often feels like a lack of job security. So, when people say my boss can fire me without any reason, the accurate answer is yes, under the at-will rule, they generally can. But if that firing is connected to discrimination, retaliation, or other unlawful reasons, then the law steps in. Understanding this starting point is crucial before we explore the specific exceptions that protect you. Part 2. Illegal reasons for firing. Discrimination. Title 7. ADA. ADEA. While the at-will rule allows employers to fire workers without explanation, there are clear limits when it comes to discrimination. Federal civil rights laws make it absolutely illegal to fire someone for reasons tied to protected characteristics, such as race, gender, religion, disability, or age. The foundation here is Title VII of the Civil Rights Act of 1964. Title VII makes it unlawful for employers to discriminate in hiring, firing, promotions, or compensation based on race, color, religion, sex, or national origin. That means if your employer decides to fire you simply because of your ethnicity or because you practice a certain faith, that firing is unlawful, even if they try to cover it up with vague excuses. Another key law is the Americans with Disabilities Act, ADA. Under the ADA, an employer cannot terminate you because of a disability if you can perform the essential duties of your job with or without reasonable accommodation. For example, if you have diabetes and require flexible breaks to manage your condition, your employer must work with you unless providing that accommodation would create an undue hardship. Firing you just because you have a medical condition would be against the law. The Age Discrimination in Employment Act, ADEA, adds another layer of protection. It applies to workers aged 40 and older. If a company lays off older workers in favor of keeping younger employees, even when the older workers are equally or more qualified, that can be illegal age discrimination. Courts and the Equal Employment Opportunity Commission, EEOC, often investigate cases like these. Let's also talk about retaliation. Suppose you report sexual harassment to HR or you file a complaint with the EECC. If, shortly after your employer terminates you, that's not just unfair, it's retaliation and it's illegal under federal law. In fact, EECC data consistently shows that retaliation is the most common basis for workplace complaints in the United States. Here's a real-world scenario. Imagine you work at a warehouse and file a complaint about racial slurs directed at you. 2 weeks later, your manager says you're being let go for poor attitude. The timing and circumstances suggest retaliation, and under Title VII, you would have grounds to challenge that termination. So, while at-will employment means your boss doesn't have to justify every firing, discrimination laws are a firm boundary. If you're fired for who you are, your race, your religion, your age, or your disability, that's not just wrong, it's unlawful, and you have the right to fight back. Part 3. Firing in violation of public policy. Now that we've covered discrimination, let's move to another major limit on at-will employment, the public policy exception. Most states in the U.S. recognize that even if an employee is at will, an employer cannot terminate them for reasons that clearly violate public policy. So, what does public policy really mean here? In simple terms, it refers to values and duties that the law wants to encourage or protect. If you're fired for following the law, exercising a legal right, or refusing to do something illegal, that termination can be challenged in court. Here are some classic examples. Jury duty. If you get called for jury service and your employer fires you for missing work, that's almost always illegal. Jury duty is a civic responsibility, and courts have ruled that firing someone for doing it undermines public policy. Refusing to break the law. Imagine your supervisor asks you to falsify financial records. If you refuse and then lose your job, many states would see that as a wrongful termination because you were simply obeying the law. Filing for workers' compensation. In most states, employees who file a legitimate workers' compensation claim after getting hurt on the job are protected. If your boss fires you the next week because your injury increased insurance costs, that would likely violate public policy. Voting or military service. Some states protect employees who take time off to vote or who serve in the National Guard or military reserves. Punishing workers for fulfilling these duties goes against the principles of public policy. The exact scope of the public policy exception depends on state law. Some states interpret it broadly, covering many situations, while others are narrower. But across the board, the principle is the same. Employers cannot punish employees for doing what the law requires or protects. A case study helps make this real. Suppose a delivery driver reports safety violations to a state highway authority and is later fired for not being a team player. Courts could see this as a wrongful discharge in violation of public policy because society benefits when workers report unsafe practices. So, while at-will employment gives employers wide discretion, public policy serves as a safeguard. It ensures that people aren't forced to choose between keeping their jobs and obeying the law. If you ever find yourself in that position, fired for doing the right thing, you may very well have a legal claim. Part 4. Contracts and implied promises. So far, we've talked about the general at-will rule, discrimination laws, and public policy. Now let's discuss another important exception. Contracts and implied promises. At-will employment is the default, but a contract can override it. If you signed a written agreement with your employer stating that you can only be fired for cause, then the employer must honor that. For cause usually means things like serious misconduct, poor performance after warnings, or violating company rules. In these cases, the employer cannot simply wake up one day and dismiss you without explanation. Unionized employees often benefit from this kind of protection. A collective bargaining agreement negotiated by a union usually requires a just cause for termination and lays out a grievance process. This means that if you're fired, the employer must prove that the termination was justified. These agreements can provide far more job security than at-will arrangements. But what if you don't have a union and never signed a contract? That's where the idea of implied promises comes in. Courts in some states have ruled that statements made by employers, whether in employee handbooks, policy manuals, or even verbal assurances, can sometimes create enforceable rights. For example, if your company's handbook says employees will only be terminated after progressive discipline, including written warnings that may be treated as a promise. If your employer suddenly fires you without following that process, you could argue they breached an implied contract. Another scenario, suppose your supervisor repeatedly tells you, "Don't worry, you'll have a job here as long as you keep performing well." Even though it's not written down, some courts might see that as a promise of continued employment, limiting the employer's ability to fire you without cause. Of course, not every state enforces implied contract claims, and not every statement counts. Many handbooks now include disclaimers that explicitly preserve at-will status. Still, in the right circumstances, implied promises can give employees legal protection. A real-world example, in Toussaint versus Blue Cross and Blue Shield of Michigan, the Michigan Supreme Court held that oral assurances and policy manuals created an implied promise of job security, even though the employee had no written contract. This case became a landmark decision for implied contract claims. So remember, if you have a written contract, union agreement, or even a company handbook that outlines job protections, you may not be truly at will. Before assuming your employer can fire you for no reason, check whether any promises, written or implied, apply to your situation. Part 5. Retaliation, protected leave, and whistleblower laws. Even in an at-will system, the law draws a firm line when it comes to retaliation and protected activities. Employers cannot legally fire you as punishment for exercising your rights, taking protected leave, or reporting illegal behavior. These safeguards exist to encourage workers to speak up without fear of losing their jobs. Let's start with retaliation. Federal labor laws prohibit employers from retaliating against employees who assert their rights. For example, under the Fair Labor Standards Act, FLSA, you cannot be fired for filing a complaint about unpaid overtime or minimum wage violations. Under OSHA, you are protected if you report unsafe working conditions. And under civil rights laws like Title VII, ADA, or ADEA, you cannot be fired for filing a discrimination complaint. Retaliation cases make up the single largest category of charges filed with the Equal Employment Opportunity Commission, EEOC, every year. Next, let's talk about protected leave. The Family and Medical Leave Act, FMLA, entitles eligible employees to up to 12 weeks of unpaid, job-protected leave for certain family and medical reasons. If you're caring for a sick parent, welcoming a new baby, or recovering from your own serious health condition, the law ensures you can take time off without losing your job. If your employer fires you for requesting or using FMLA leave, that's a violation. Some states even expand this protection by offering paid family leave programs, which means you can receive partial wage replacement while you're out. Finally, there are whistleblower protections. These laws shield workers who report illegal activity, fraud, or threats to public safety. For example, if you discover your company is committing Medicare fraud and you report it, federal whistleblower laws protect you. The same applies if you expose securities fraud under the Sarbanes-Oxley Act or environmental violations under the Clean Air Act. Each of these laws is designed to encourage employees to come forward by protecting them against termination or retaliation. Imagine this scenario. You work for a construction company and notice serious safety violations, missing guardrails, exposed wiring, no protective gear. You file a complaint with OSHA. 2 weeks later, you're fired for attendance issues. That firing would likely be considered retaliation, and you could challenge it under whistleblower protections. So while at-will employment gives employers broad discretion, retaliation, leave rights, and whistleblower laws create strong exceptions. They ensure that workers can stand up for fairness, safety, and legality without losing their livelihoods. If you ever face termination after asserting your rights, there's a good chance the law is on your side. So, let's bring it all together. In the United States, most workers are employed at will, which means your boss can fire you without giving a reason. But that doesn't mean employers have unlimited power. Federal and state laws place clear limits. They cannot fire you because of discrimination under Title VII, ADA, or ADEA. They cannot fire you for obeying the law or filing a workers' comp claim. That's the public policy exception. If you have a contract or a union agreement, your employer must follow it, and they cannot retaliate against you for asserting your rights, taking FMLA leave, or blowing the whistle on illegal practices. So the next time someone tells you your boss can fire you for no reason and you can't do anything about it, remember, it's only half true. If this video helped, hit like, share it with your coworkers, and subscribe for more clear explanations of your workplace rights.